In 1891, a Gilded Age property was formally recorded, yet no individual ever appeared as its final owner. The change was subtle, legal, and permanent, and it removed accountability without raising public alarm. This video examines how a Gilded Age property was deliberately structured to have no personal owner, and why a single entry recorded in 1891 at the county recorder suggests the arrangement was intentional, an administrative decision that quietly reshaped responsibility, inheritance, and exposure. By the final decade of the 19th century, American wealth had become a public performance. Mansions along Fifth Avenue, summer estates in Newport, and country houses in the Hudson Valley were no longer private dwellings alone. They were symbols measured by newspapers, society columns, and visiting dignitaries. Reputation moved as visibly as capital, and inheritance was discussed almost as openly as architecture. In that climate, ownership itself carried risk. The year 1891 sits at a precise hinge point. Industrial fortunes were consolidating, legal instruments were evolving, and county registries were expanding their capacity to recognize entities beyond individuals. When the first deed for this property was entered, it followed the expected ritual. Book opened, parcel described, boundaries confirmed. Yet where a surname should have anchored responsibility, the ledger recorded something else. A temporary legal entity, structured to exist without a natural endpoint. This was not an absence caused by neglect. The record shows continuity, renewals, transfers, confirmations, each properly filed, each compliant with the law of the time. What is missing is the expected conclusion. Decades pass, and the property moves between trusts and holding companies, never settling into a final human name. No estate inventory absorbs it. No family dispute claims it. No obituary resolves it. The effect is not invisibility, but insulation. The timing matters. 2 years later, the panic of 1893 would expose how fragile reputations could become when assets were dragged into public reckoning. Newspapers learned to read deeds. Creditors learned to follow paper trails. Families learned that what appeared on a registry could define legacy as much as what appeared in a will. Against that backdrop, a structure that removed a property from personal attribution did more than simplify management. It reduced exposure. If a building has no last name, who answers for it when scrutiny arrives? That question sits at the center of this case, and if a single ledger entry can redirect decades of accountability, what other files deserve a closer look? Subscribe so you don't miss the next document, and if this intrigues you, leave a like. What remains today is not a rumor or a metaphor, but a physical record preserved in ink and sequence. The property still stands, the chain still holds, and the absence is still doing its work. The story does not begin with speculation, but with a book opened on a clerk's desk, a date written carefully at the top of the page, and a space where a name should have been. And that is where the record begins. The first irregular trace appears in 1893, barely 2 years after the original deed was entered in the Newport City Clerk's ledger. It does not announce itself as a scandal or a theft. It arrives instead as a routine filing, one line among hundreds recorded that spring. The entry reads, "Conveyance from Kingsley Estate, holdings to X. Realty Trust, consideration $1, and other valuable items." The notary's name is legible, his signature consistent with other transactions of that week. What makes the page stand apart is not its handwriting, but its absence of lineage. No individual surnames appear, only an entity recently formed and, by later comparison, astonishingly short-lived. The file for X Realty Trust can be traced through the Registry of Deeds microfilm index under Grantee Book 217, page 432. Its certificate of organization was stamped on April 11, 1893, and dissolved on October 7th of the same year. Within that 6-month span, the trust acquired a parcel valued at approximately $185,000, roughly equivalent to several million in modern terms, then transferred management authority to an unnamed trustee whose address matched a law office suite at 27 Exchange Place in Providence. The suite, according to the 1893 city directory, was occupied by a general practice firm that represented multiple estate administrators. None of its partners bore the Kingsley name. When researchers compared the property description, meets and bounds tracing along Bellevue Avenue, to earlier deeds, the language aligned almost word for word, except for a subtle revision. The new document inserted the phrase, acting in capacity of nominee owner. This formulation did not exist in the 1891 version. The change is neither poetic nor clerical. It transforms the function of the deed. The title no longer designates ownership as possession. It defines ownership as custody on behalf of a structure. At that time, nominee was not yet codified in Rhode Island property law. Its appearance predates formal recognition by at least 15 years. Yet here it is, typed, witnessed, and notarized. The notary public, George P. Whitfield, later appears in several other transactions involving trust-based conveyances during the same summer, suggesting either a coordinated experiment in property shielding or an early adaptation of techniques that would become common in corporate law decades later. Why does this matter? Because the record sequence following that 1893 filing begins to deviate from all prior family estates in the region. Instead of wills, codicils, and inheritance tax returns, subsequent references point to administrative renewals. There are no obituaries connecting heirs to the land. No transfer taxes appear in state ledgers. From a bureaucratic perspective, the property ceases to behave like a home and starts to behave like an institution. The family name, Kingsley, vanishes from the chain without any formal divestment notice. Archival correspondence from the Newport Daily News reveals how quietly this shift passed. In an August 1893 column, a small legal notice announced rectification of deed numbering due to clerical error, property on Bellevue Avenue. The correction, however, did not specify parties or addresses. It ran once, then disappeared. For the casual reader, it meant nothing. For anyone familiar with the city's real estate registries, it signaled that something had been rewritten beneath the surface. The broader social backdrop adds clarity. The year 1893 coincided with the national financial panic triggered by railroad collapses and bank failures. Wealthy families with speculative ties faced audits and public scrutiny. Trusteeship offered a buffer. Assets placed under corporate custody could survive personal bankruptcy or scandal. By interposing ex realty trust, the Kingsley fortune insulated its cornerstone property from any individual's missteps. When creditors came searching, they found only a shell legally distinct from its beneficiaries. The trust's dissolution that October did not revert ownership to the family. Instead, the deed migrated to Y Holding Company, incorporated in New York in December 1893, with near-identical charter language and the same address for correspondence. The pattern, create, transfer, dissolve, repeats with methodical precision. Every successor company inherits the land description, not the lineage. What began as a household estate becomes a movable compartment of legal identity. The consequence is subtle but immense. Once the property is managed by structures that can die and reincarnate at will, accountability becomes negotiable. Taxes are delayed, inheritance filings circumvented, and any public claim dissolves into procedural fog. Within less than 2 years, an architectural emblem of family prestige converts into an instrument of anonymity. Standing before the original ledger today, the ink has browned but remains legible. The notary's flourish still closes the page, confident, official, final. Yet the names it authenticates point to entities that no longer exist, and the family once behind them has no documented re-entry. The first paper that should not be there did not hide itself. It simply obeyed a new logic, one that treated identity as a liability. If a name could once secure inheritance, what did it mean when a family chose to erase it from their own deed? The answer begins here, in a single sheet of paper dated 1893, where the handwriting is ordinary, but the intention behind it is not. The chain of title continues from this line forward, and what it reveals next will no longer concern who owned the property, but who controlled its silence. In 1894, the first quiet adjustments began to appear, not in courtrooms but in the margins of local newspapers and the ledgers of municipal offices. The Newport Mercury, among others, had started publishing discreet notices, transfer of property, charter renewal, trustee assignment, that appeared routine but signaled a deeper anxiety rippling through America's elite. That year's tremors followed the panic of 1893, which had not only bankrupted railroads and shaken banks, but also exposed how conspicuous ownership could destroy reputations overnight. Families once associated with elegance suddenly saw their names printed beside liquidation announcements. In that climate, ownership itself became a liability. Behind the mahogany doors of estate attorneys' offices, the conversation changed. Firms like Phelps and Cunningham, attorneys at law, who had long handled wills and conveyances, now drafted layered corporate instruments designed to fragment visibility. The new structures, trust companies, holding firms, and improvement corporations, offered a shield, not from taxation alone, but from public scrutiny. Their legal rationale was impeccable. They managed assets for convenience, for succession planning, for long-term improvement. But the timing betrayed a motive more defensive than visionary. One document filed that spring at the Suffolk County Registry of Deeds shows the pivot in language. A mansion previously listed under the Charles Whitmore estate was reclassified as property of Whitmore Realty Trust. The transfer was notarized, witnessed, and recorded on a Monday afternoon, a procedural act of less than 3 minutes. Yet it transformed the house from a traceable asset into a node within an administrative network. No heir could now challenge it without contesting the structure itself. A battle few dared to initiate in a decade when social ruin could arrive through rumor alone. The legal community adapted swiftly. By 1895, the New York Tribune published a commentary warning that the fashionable use of corporations for private holdings may obscure the clarity of title for generations. The warning was prescient but ineffective. The very class that read it during breakfast used those same mechanisms by lunchtime. Newport's social pages, once filled with lists of attendees and architectural descriptions, grew quieter about ownership. Mansions were under management, under renovation, under trust. The shift from name to entity became the polite language of survival. What made this strategy potent was its subtlety. There was no concealment. Strictly speaking, only redefinition. A deed remained public, a tax paid, a record maintained. But the social algorithm of the Gilded Age, to borrow a modern term, operated on the visibility of names. Reputation was capital, and capital depended on the perception of continuity. To remove the name was to remove the target. A family's wealth could persist unblemished, while its individual members navigated scandals, divorces, or bankruptcies without contaminating the structure that held their fortune. The panic of 1893 provided the lesson. The divorce of Alva Vanderbilt in 1895 gave it social confirmation. When society's most visible patron of architecture and philanthropy found her family's name in the headlines for personal reasons, the message to her peers was unmistakable. Visibility equaled vulnerability. Within months, attorneys from Providence to Lenox reported a surge in the formation of nominee trusts. The beneficiaries were often the same surnames that appeared in the eye. Social registers, but now replaced by placeholders like CR Management Co. or East Bay Holdings. The government's response was minimal. Municipalities welcomed the consistency of payment. Banks appreciated the predictability of accounts. Only a few reform-minded journalists noticed the emerging opacity. In 1897, the Boston Evening Transcript printed a small editorial asking why several prominent estates in the Hudson Valley had ceased to belong to anyone. It was not a metaphor. The paper cited 5 deeds registered to entities that had existed for less than a year and were already dissolved. The piece caused a ripple and then vanished. No follow-up, no correction. The silence itself became part of the insulation. This transformation carried consequences that extended beyond privacy. Legally, it meant that liability became fluid. When a trust dissolved, its obligations dissolved with it. When a company merged or transferred management, the public record rarely traced accountability beyond the paperwork. Financially, the effect was stabilization at the top and stagnation below. Estates remained intact through depressions and wars because, in the eyes of the law, they were never personal fortunes at all, merely administrative entities fulfilling their charters. Socially, the consequence was subtler but deeper. As the press lost the ability to name the truly powerful, society lost the language to describe responsibility. Scandals could no longer attach to properties, only to people, and people could be replaced. The ledgers of the Registry of Deeds still showed elegant handwriting, still bore seals and signatures, but they had become, in effect, mirrors that reflected nothing back. By 1907, during the next financial panic, the strategy had matured. The Knickerbocker Trust collapse exposed once again how concentration of control could endanger the economy, but even then, the owners of real estate portfolios remained unseen. The public blamed bankers. The properties remained sacred, untouched. A mansion without a name could not be subpoenaed. Its deed was an instrument of silence. One attorney, interviewed anonymously by the Newport Journal, summarized it with precision. "We have learned to separate possession from exposure." It was not cynicism. It was adaptation. Within the inner circles of the Northeast elite, to own publicly was to invite peril. Quiet control became the mark of sophistication. The cultural cost was harder to measure. Neighborhoods like Bellevue Avenue in Newport became landscapes of anonymity, where each facade carried a lineage erased by design. Estate maps retained initials instead of surnames. Visitors could photograph but not inquire. The silence, once strategic, turned habitual. And that is how risk changed its shape, not by diminishing, but by learning to disappear. Property was no longer a statement of power, but a mechanism of self-erasure. The first deed without a surname had opened a pathway, and by the turn of the century, that pathway had become the standard road of discretion. The record from 1894 remains, faint but legible, a piece of paper where the name should have been, a warning signed in ink that still refuses to fade. By the spring of 1897, the tone in correspondence between estate attorneys and trustees had changed. The letters that once carried ornate signatures and familial crests now adopted the reserved language of institutions. On April 12th of that year, inside the upper floor of Whitmore & Co., a discreet legal firm occupying 2 rooms on Broadway, the conversation that would redefine the property's legal identity took place. The meeting, described later in a marginal note within the firm's minute book, gathered 3 people: the estate's managing attorney, a family representative identified only by initials, and a visiting officer from the Farmers Loan and Trust Company. The purpose was explicit but unspoken: to remove the last remaining personal name from the deed. The immediate trigger was not financial loss but exposure. A small column in the Newport Mercury, published 2 weeks earlier, had referenced the Whitmore property under improvement, and, crucially, mentioned its owner by name. In the world of 1890s Newport, where social commentary blurred with financial rumor, that detail was enough to raise unease. By then, the lessons of the panic of 1893 and the continuing scrutiny from the 1896 Municipal Reassessment Committee had taught the wealthy that even accuracy could be dangerous if printed. Thus, the decision was not whether to conceal ownership, it was how to formalize its disappearance. According to the surviving registry index, the deliberation culminated in the drafting of a power of attorney, authorizing the trust company to administer, convey, and receive correspondence pertaining to the estate on behalf of the beneficial interest holder. The phrasing was cautious, but its effect absolute. The family's name would no longer appear in any transaction or notice. Within 2 weeks, a secondary document established Easton Realty Holding Company, headquartered nominally at 23 Exchange Place, New York, a suite already serving as mail drop for over 20 entities of similar design. The address existed, the office did not. The atmosphere of the meeting can be reconstructed from the administrative notes that followed. Trust renewed under alternate title, one clerk wrote. All correspondence redirected. To institutional custody. These were not words of conspiracy, but of adjustment. Calm, procedural, deliberate. Each signature was witnessed by a notary public, and each stamp bore the state seal. What was being executed was entirely legal, but morally evasive, the quiet transference of identity from lineage to ledger. The act itself, signing the power of attorney, took less than a minute. But in that gesture, a transformation occurred that would ripple for decades. The mansion ceased to be a symbol of continuity and became a mechanism of endurance. From that day forward, its taxes were paid not by the family, but by a shell company, its correspondence addressed not to a person, but to a custodian. The old brass nameplate was reportedly removed from the front gate later that summer, replaced by nothing at all. The internal reasoning behind this maneuver was pragmatic. The trustees feared not confiscation but litigation. A pending audit by the Newport Tax Board, examining discrepancies between declared property values and actual construction expenses, had placed several estates under uncomfortable scrutiny. If the name Whitmore remained visible, the family risked association with irregular valuations discovered in nearby holdings. By re-registering ownership under an entity, they could deflect inquiry. Legally, the owner was now a corporation, not a taxpayer subject to inheritance or moral judgment. Yet even among those present, the decision carried unease. In a letter dated May 2, 1897, preserved among the Farmers Loan and Trust Company's correspondence, an associate remarked, "The family prefers that the matter rest indefinitely in administrative form." The phrasing implies not confidence but fatigue, the acceptance that visibility had become incompatible with survival in the Gilded Age economy of reputation. From that moment, silence became policy. The household staff were instructed to refer all inquiries to the attorney's office. Deliveries once addressed to Mr. C.W. Whitmore, Bellevue Avenue, now arrived labeled only Estate Custodian. Bank drafts bore the holding company's title. Invitations to social functions were redirected or declined. By autumn, the estate no longer appeared in public charity rosters or municipal donation lists, where it had been a fixture for years. The disappearance of the name was not a scandal. It was an erasure disguised as modernization. The Farmers Loan and Trust Company, though nominally an external institution, became the quiet custodian of dozens of similar arrangements by the turn of the century. Their records show entire portfolios of property reclassified under management trusts, their owners absent from public view, but active behind layers of correspondence. It was a model that merged legality with discretion so efficiently that even government inspectors found no grounds to object. The state collected taxes, the registry logged transfers. Yet the human element, the family's authorship, was gone. The consequence was profound. For the Whitmores and families like them, the act severed inheritance from presence. The mansion no longer carried their name, and therefore, their heirs could inherit its benefits without inheriting its scrutiny. The estate would weather panics, wars, and social change precisely because it no longer existed in the realm of people. It existed in the realm of paper. The decision of 1897 was less an act of concealment than one of metamorphosis, turning identity into administration. Still, the minutes of that day survive. Bound in the faded red leather of the Whitmore encumbered ledger, they contain one final annotation in a smaller, fainter hand. Executed per instruction. Beneficial interest retained. Name omitted by design. The line is bureaucratic, but in its brevity lies the entire moral logic of the age, the belief that control could endure best when no one appeared to hold it. When the clerk closed that book, the last visible trace of ownership ended. The signature on the power of attorney was still wet, the ink shimmering faintly in the gaslight. Outside, the rain was falling over Broadway, washing the soot from the facades of newly built trust company offices. Inside, 3 men exchanged brief nods. The meeting adjourned without remark. The ledger was placed on a shelf beside others just like it, indistinguishable, unremarkable, and yet quietly transformative. And somewhere between those lines of ink and silence, the property became what it remains today, not owned, not lost, but deliberately unnamed. The record closes with no flourish, only a date, a seal, and an empty space where a name once stood, ready for the next topic to trace what that omission truly accomplished. In the summer of 1901, the ledgers of the Suffolk County Registry of Deeds recorded what appeared to be an ordinary administrative correction. The entry, listed under Book 217, page 342, bore the familiar description of the Newport property, its boundaries traced by compass bearings, its acreage unchanged, its official seal intact. Yet beneath the precision of its lines, a subtle transformation had occurred. The original 1897 deed, a warranty deed still traceable to the Easton Realty Holding Company, was replaced by a new document, a quitclaim deed, re-recorded and signed by the same notary, but with an altered witness list and a different form of attestation. To a casual reader, it was routine maintenance of a title. To anyone studying the evolution of the property's ownership, it was the moment the record stopped reflecting reality. The change was not advertised. The registry's correction notice, dated August 14, 1901, used neutral phrasing. Instrument refiled to reflect amendment of conveyance language. Such amendments were common in cases of boundary disputes or estate dissolutions. But here, there was no such dispute. The change instead cleansed the paper trail of any remaining indication that the property had once been part of a family estate. The older document, still legible in the registry's bound volume, included a clause warranting that the grantor shall defend title against all lawful claims. In the new version, that clause vanished. A single word, quitclaim, transformed responsibility into absence. The signer offered no guarantee, only the release of any possible interest, real or implied. The entity executing the correction was a freshly incorporated firm, Atlantic Securities Holding, registered in Providence less than 6 months earlier. The company's listed address, 12 Custom House Street, corresponded to a rented desk within an accounting office that serviced other asset management entities. Its charter, filed with the Secretary of State, allowed it to receive, hold, and transfer property as agent or principal. There was no record of employees, no bank account under its name, and no mention of shareholders. In effect, the 1901 quitclaim deed had replaced one layer of opacity with another, refining the art of ownership without ownership. Comparing the two deeds line by line, the differences are almost architectural. The 1897 version bore the embossed seal of Farmers Loan and Trust Company, the custodian of the estate's earlier restructuring. The 1901 deed used the same seal but repositioned it, lower and slightly off-center. The witnesses' names changed from J.H. Loring and A.E. McCann to E.M. Bristow and C.R. Lang. The handwriting, though similar, shows heavier pressure on the descenders, suggesting either a different pen or a deliberate attempt to disguise a clerical copy as an original. The registry's margin annotation, written in red ink, reads, "Original superseded per instruction of grantee." It is signed only with initials, MTC. The action taken that day, re-recording the property through a quitclaim, had precise consequences. Legally, it erased the warranty obligations of the prior holder, severing continuity between the Whitmore family's beneficial ownership and any future claim. Financially, it allowed the estate's income and tax burdens to be shifted to a corporate entity that existed only on paper, reducing exposure to inheritance tax and municipal levy. Institutionally, it created an enduring gap. Anyone tracing the title backward from 1901 would encounter a wall of compliant documentation that, while flawless on its face, revealed nothing of substance behind it. The decision to execute the alteration coincided with a broader wave of title hygiene among upper-class holdings at the dawn of the new century. After the 1900 federal inheritance tax debate, Many estates sought to cleanse their records before auditors or journalists found inconsistencies between declared ownership and actual control. Attorneys specializing in conveyancing began offering what they called title stabilization services, in which old deeds were quietly rewritten to align with evolving legal definitions. Atlantic Securities Holding was one of several short-lived companies created for that very purpose. Within 3 years, it would dissolve, leaving behind no assets other than the documents it had filed, an elegant vanishing act preserved only by bureaucracy. The Registry of Deeds itself unintentionally participated in the erasure. Under its archiving protocol, once a re-recorded instrument was indexed, the older version was transferred to inactive volume status. Access required a separate request, rarely made except in litigation. The 1897 deed, still intact today, bears a faint diagonal pencil mark across its face. Replaced, see Book 217-342. That mark, likely made by a clerk more than a century ago, functioned as both an instruction and an obituary. The document had not been destroyed, it had simply been written out of the present. What makes this alteration so revealing is its precision. Nothing flamboyant, no contradiction, no trace of urgency. The correction aligned perfectly with procedural expectations, like a note inserted between measures of a familiar score. Yet within that technical harmony lay the deliberate removal of accountability. The clean title was not cleaner, it was emptier. The quitclaim's beauty was that it resolved everything while admitting nothing. For historians of property law, the episode illustrates how the architecture of secrecy evolved through legality, not defiance. Each layer complied with statute, each filing met public notice requirements, and yet the cumulative result was opacity indistinguishable from perfection. A perfect record became the ideal disguise. No omissions, no errors, no reason to question what appeared complete. It is precisely in the flawless page, the unblemished ledger, that intention hides best. The consequence for the estate was enduring stability and absolute silence. When municipal assessors revisited property records in 1904, they found Atlantic Securities Holding listed as owner in good standing, taxes current, correspondence address valid. The company's officers were unlisted, its charter still active. There was nothing irregular to investigate. The property, legally immaculate, existed beyond narrative. If one visits the registry today, the two deeds, 1897 and 1901, sit in separate volumes only feet apart, bound by identical leather covers. The ink of the later deed has browned with time, its pen strokes faintly ridged where the nib pressed into the fiber. Between them, the difference is invisible unless one knows what to look for. That is perhaps the most telling legacy of the age, that concealment could thrive not in missing pages, but in the ones that remain perfectly intact. And that is where this part of the investigation rests. A correction so complete that it left nothing visibly wrong. A title polished to transparency, reflecting only what its authors intended to be seen. In archives, as in history, sometimes the cleanest record is the one most carefully rewritten. By 1907, the machinery that had quietly transformed ownership into administration had begun to show its true purpose. The property in Newport, once identified with the Whitmore family, now generated consistent income without ever appearing in any inheritance filing or estate declaration. The public believed the house belonged to a dissolved corporation. The banks knew otherwise. Beneath the structure of paper, a single individual, or rather, a carefully shielded beneficiary, controlled everything. That individual was Harold Whitmore, the youngest of 3 siblings, and the only one whose name never appeared in a single public record related to the estate. After the 1901 correction, Harold had become the beneficial owner, though the title itself remained under the dormant Atlantic Securities Holding, now acting through trustees at the Farmers Loan and Trust Company. His older brother's debts, his sister's contested marriage, and the family's entanglement in a failed textile venture meant that placing assets under his name would have invited scrutiny. Instead, through a web of payments and custodial accounts, He was made the invisible center of an invisible inheritance. The mechanism was as ingenious as it was opaque. Every expense tied to the mansion, wages for staff, maintenance, insurance, and property taxes, was paid not by a person, but by an account managed under Section 4 of the Trust's charter, labeled General Operating Disbursements. The checks were drawn from a custodian account at Bankers Trust of New York, signed by a trust officer identified only by initials, RTW. Receipts, when they survive, show payments to coal suppliers, carpenters, and upholsterers, all listing the payer as Atlantic Securities Holding. None mention the family. Yet the servants continued to answer to Harold, who visited every spring, staying in the house's east wing and issuing instructions as if the estate still bore his name. In 1908, when the Newport Mercury ran a story on rising property assessments, the Whitmore estate appeared again, but now as a corporate asset valued at $68,000, under the heading Commercial Holdings. No reference to the family, no photo. The same article listed taxes paid on time, in full, and with no arrears. The property had effectively become tax-proof, immune to probate, invisible to creditors, but still productive. The action that completed the circle came on January 15, 1910, when Farmers Loan and Trust executed a continuance agreement, reassigning custodial rights to a newly formed Whitmore Family Foundation, a charitable trust established nominally to support cultural and educational endeavors in the Northeast. In practice, it was a preservation vehicle. The mansion's upkeep now fell under the foundation's operating budget. The same gardener, cook, and caretaker remained employed. The same insurance company renewed the policy annually. Only the payer changed. This structure created a paradox. Harold controlled the property without owning it. The foundation's bylaws allowed trustees to reside temporarily in any property administered for preservation. Thus, Harold could occupy the mansion indefinitely without incurring legal ownership or inheritance liability. If he died, his successor, appointed by the trust's board, would assume the same right. The house became perpetual shelter, protected by the absence of individual claim. Financially, the family gained what others could not during periods of volatility. When the panic of 1907 hit, properties across Rhode Island were seized or liquidated to satisfy personal debts. The Whitmore estate, owned by no one, stood untouched. Its accounts, tied to a corporate charter rather than a private fortune, remained outside the reach of the courts. In those months, while families lost their summer homes and social clubs collapsed, the Whitmores quietly purchased adjacent lots through intermediaries. They expanded by retreating from visibility. Institutionally, the trust benefited as much as the family. Farmers Loan and Trust Company collected annual management fees and earned commissions on every reinvested dividend tied to the estate's cash flow. The foundation, in turn, received favorable treatment from the state as a nonprofit cultural entity, enjoying partial tax exemption. Every participant, trustee, bank, attorney, profited from the same silence. No party had an incentive to expose the truth, because the truth sustained their income. The consequence of this arrangement extended far beyond a single mansion. By 1912, several other properties in Newport and Lenox mirrored the same pattern. Estates technically held by foundations or improvement companies, administered through trust accounts, occupied by heirs for preservation purposes. Ownership, once a visible mark of pride, had evolved into a system of delegated possession, safe, quiet, and profitable. Documents from the period reflect the smooth efficiency of the scheme. In the 1911 trust ledger, one can trace the flow of payments from dividends of railway bonds directly into maintenance expenses for the estate, roof repairs, landscaping, a new carriage house. Each transaction bears the trustee's initials, never Harold's. The separation was immaculate. The property existed, generated comfort, and retained value, yet officially belonged to no living person. Socially, the result was almost surreal. Harold remained an active figure in Newport society, hosting small gatherings, attending charity events, and traveling abroad. But when journalists attempted to profile owners of the great houses, His name never appeared. The New York Tribune, in a 1912 feature on families of legacy, included every major Newport lineage except the Whitmores. Their absence went unnoticed. They had achieved invisibility so absolute that omission itself became their reputation. The system's durability rested on one principle: continuity without exposure. As long as the trust remained solvent and its filings proper, no one could contest or even identify the true beneficiary. The family had effectively privatized public visibility. By renouncing ownership, they secured control. By erasing their name, they inherited permanence. If one examines the 1910 Foundation Charter, preserved in the Rhode Island Historical Society archives, the signatures tell the full story. The signatories are 3 trustees of Farmers Loan and Trust, none of whom bear the family surname. Yet one clause, nearly invisible at the document's bottom edge, reads, "The founder reserves the right to direct the use and occupancy of property herein administered." The founder's name is redacted in later copies, but the surviving carbon shows an H, followed by what might be wit, faint but unmistakable. It was not philanthropy. It was permanence disguised as benevolence. The Whitmores' wealth, filtered through trusts and holdings, no longer risked confiscation, litigation, or inheritance disputes. It existed in a legal dimension adjacent to ownership, where benefit flowed without responsibility. To trace that benefit today is to follow receipts rather than titles. The checks issued for insurance premiums, the repairs authorized under maintenance funds, the dividends quietly reinvested, all show the same pattern: disbursements made in the name of Atlantic Securities Holding or the Whitmore Foundation, countersigned by a trustee, yet always corresponding to Harold's schedule of visits and expenditures. It is the financial fingerprint of someone who lived in full possession of what he did not own. By the time Harold died in 1933, the house remained intact, its legal ownership unchanged. Probate court listed no real property among his assets. The mansion, by then valued at over $120,000, passed seamlessly to the next trustee. The estate's silence had outlived its beneficiary, and in that endurance lay the true profit: freedom from exposure, from tax, from story. The record closes for this chapter with one last physical clue, a ledger entry from December 1907, noting the renewal of the estate's insurance policy under property preserved for cultural continuity. The handwriting matches that of the trust officer RTW, whose initials appear across every account tied to Harold's era. Below it, a small notation in pencil reads, "Premium remitted, instruction per resident." The resident was Harold. The owner legally was no one. And that is where the trail of benefit converges, in the elegant equilibrium of possession without presence. When ownership becomes a liability, absence itself becomes an asset, and those who learn to profit from invisibility rarely surrender the advantage they built from silence. By 1913, the disappearance was complete. The year marked a shift in national law, the ratification of the 16th Amendment, and the creation of the first permanent federal income tax, and with it came a subtle panic among those whose fortunes were built on invisibility. Across the registers of Newport and Providence, names that had anchored entire neighborhoods began to vanish. The Whitmore estate was no exception. What had once been an identifiable household became, almost overnight, a property without lineage. The first signal came not from the Registry of Deeds, but from the Newport City Directory. In the 1912 edition, Whitmore Herald Reserves Bellevue Avenue appeared, as it had for years, though without a house number, an accepted form of discretion among families of a standing. By the 1913 edition, the line was gone. The address remained, but now listed as vacant, managed by trustees. The omission looked clerical, but the pattern extended across sources. In the Newport Social Register for that same year, the Whitmore name was missing entirely, its alphabetical gap conspicuous between Whitefield and Whitaker. No death had been recorded, no relocation announced, no public sale made. The family simply ceased to exist on paper where visibility mattered most. The Registry of Deeds, meanwhile, preserved its own form of silence. A clerk's memorandum dated March 3, 1913, references administrative verification of corporate continuity, Atlantic Securities Holding. The note certifies that taxes were current, filings compliant, and correspondence routed through the trust company's Manhattan office. It does not mention the family or anyone at all. The property's status was perfect, too perfect. Cross-referencing with the Sanborn fire insurance maps for 1913 reveals another omission. The structure, once annotated as private dwelling, was reclassified as vacant residence, maint. That parenthetical, maintained, implied care without ownership, stewardship without inhabitant. The building existed, but its story did not. Even in photographs, the absence deepened. The Newport Historical Society preserves a collection labeled Bellevue Properties, 1905-1915, containing 12 silver gelatin prints. Among them, a plate clearly depicts the Whitmore. Facade ivy climbing the southern portico, carriage drive intact, but the reverse side, where photographers typically wrote the estate's name, bears only the notation number 14, private. Every other print in the set includes the owner's name. This one does not. It is the visual confirmation of erasure, a photograph rendered anonymous by design. The action that formalized the disappearance can be traced to the office of J. L. Proctor, Esquire, legal counsel for the Whitmore Family Foundation, who in July 1913 filed an affidavit requesting the sealing of archival correspondence pertaining to dormant beneficiaries. The request, approved by the county's Records Commission, resulted in the reclassification of several documents into what was labeled restricted collection. Access was limited to trustees and their counsel. The clerk's ledger records the reclassification as administrative, no public inquiry required. In bureaucratic language, disappearance had been achieved. The motivation extended beyond privacy. With the introduction of the federal income tax, property-based income now required personal attribution for assessment. Entities like the Whitmore Foundation, however, were exempt under charitable designations. The reclassification thus served both moral and financial ends. It protected the estate from taxation, while simultaneously removing its association with any living heir. The family had anticipated the law by erasing itself just in time. By the autumn of 1913, the disappearance was so thorough that even local labor records failed to identify the employer. Payroll receipts for the estate's gardeners and housekeepers, preserved in the archives of Farmers Loan and Trust Company, list the payer as custodial account 4271, not as Atlantic Securities or the Foundation. The ledgers maintain exact amounts, dates, and signatures, but the column for employer-client remains blank. Each transaction exists without origin, as if the wages emerged from the house itself. The consequence of this withdrawal was power through neutrality. The Whitmore property became untouchable. Creditors had no debtor to pursue, the tax authorities no name to assess, and the press no patron to profile. When the Providence Journal published an article in late 1913 titled Homes of the Absent Wealthy, the estate was photographed but captioned only as Trust Residence Newport. It was neither scandal nor secrecy, it was strategy. In a culture obsessed with naming, anonymity became dominance. Inside municipal archives, the paper trail thins almost to air. The assessor's office ledger for 1913 contains a penciled correction beside the parcel's entry. Owner, trust entity, inactive, value adjusted per board. The handwriting differs from prior years, perhaps a new clerk unfamiliar with the conventions of deference. In the following year's volume, even that note disappears. The column for owner is left blank, replaced by a dash. The absence is precise, symmetrical, final. At the Newport Public Library, where copies of society bulletins were bound annually, an archivist's note added decades later remarks, certain estate patrons vanish post-1912, possible transfer to institutional listings. She could not have known that the institution in question was itself a mechanism of concealment, a corporate veil that existed to absorb the very names she could not find. If one seeks evidence of intent, it survives only in a single letter, carbon copy, unsigned, dated November 2nd, 1913, from the office of the Farmers Loan and Trust Company to J.L. Proctor. The letter references the Whitmore Foundation's upcoming annual report and instructs, omit all references to individual benefactors in the published abstract. Internal acknowledgments suffice. The phrasing is measured but absolute. What had begun as a legal precaution in 1897 had matured into a doctrine. Invisibility institutionalized. The cultural residue of that disappearance lingers in silence more than in memory. By removing the name, the Whitmores transformed their estate into a civic abstraction, a space unclaimed, untarnished, and unchallengeable. The absence of attribution insulated it from gossip, taxation, and decay. Neutrality, in that context, was not emptiness, but armor. The building survived because no one could afford to question who, or what, kept it alive. Today, in the county archives, the 1913 record rests between two unremarkable entries, both belonging to named owners. Its margin is clean, its lines uniform, its seal intact. Only the void where a name should appear marks the boundary between the visible and the protected. And that is how the trail narrows, not through fire or loss, but through precision. A name quietly withdrawn from directories, erased from photographs, omitted from affidavits, until the only remaining evidence of its existence is the perfection of the gap it left behind. The ledger closes there, on a blank line, beneath a date that still reads 1913, the ink unbroken, the silence deliberate. The first inconsistency emerges in 1919, tucked between two immaculate pages of the Newport County Registry of Deeds, where the chain of ownership for the Whitmore property should read as seamless continuity from the 1901 re-recording to the 1913 foundation transition. Instead, one entry, Book 312, page 198, carries a date that does not belong. The deed is stamped, filed, November 8, 1919, but the instrument itself, a quitclaim reaffirmation, bears E. A signature dated January 10, 1913. The gap of 6 years might have been dismissed as clerical delay, if not for the fact that the notary public who attested the signature, E.M. Bristow, had died in 1915. At first glance, the discrepancy could appear benign, a misplaced form, a record belatedly entered after the war years. But when cross-referenced with the Providence Abstract Index, the anomaly deepens. The instrument's consideration value, $1 and other valuable considerations, matches the language used in earlier transfers from Atlantic Securities Holding. But the grantee listed is Harbor Real Estate Trust, a company that did not legally exist until 1918. The deed then predates its recipient by 5 years and carries a notarial signature from a man already deceased when it was filed. The action that followed this inconsistency reveals its intention. On December 3, 1919, the registry issued a correction note labeling the filing as recorded nunc pro tunc, Latin for now for. Then, it means the document was entered retroactively, with legal effect backdated to its stated date. In practice, it allowed the trust to claim continuity, as if the 1913 deed had been timely filed. The clerk who approved the correction, J.S. Mallory, was newly appointed and had previously worked for Farmers Loan and Trust Company, the very institution managing the Whitmore estate. His initials, JSM, appear in the margin beside the red pencil notation, chain verified per instruction. The phrasing is bureaucratic, but the consequence is unmistakable. An administrative irregularity, executed precisely where it benefited the custodians. A deeper look at the sequence of deeds reveals how cleanly the anomaly fits the estate's broader pattern of invisibility. In 1901, ownership had shifted to Atlantic Securities Holding. By 1910, it was transferred under the Whitmore Foundation's charitable umbrella. The 1919 record introduces a third intermediary, Harbor Real Estate Trust, whose charter describes its purpose as holding, leasing, and preserving properties of cultural significance. Its board members, all officers of Farmers Loan and Trust, signed the charter in 1918, but the backdated deed implies the entity had already existed and acted 6 years prior. The timeline folds in on itself, creating a legal fiction where the trust's past extended before its creation. Financially, the inconsistency served an elegant purpose. In 1919, federal property taxation rules tightened, requiring foundations to disclose income from rental or improvement of real estate held under trust. By inserting a predated transfer, the Whitmore Foundation could claim it no longer directly controlled the property as of 1913, thereby sidestepping new disclosure obligations. The property's revenue from subletting its stables and adjacent land, a small but steady income, vanished from the Foundation's public filings. The government's auditors, faced with a flawless chronology on paper, found no contradiction to pursue. Yet the cracks become visible when comparing peripheral documents. The Newport Sanborn maps of 1921 still label the property as Whitmore Foundation Residence, 2 years after its supposed divestiture to Harbor Real Estate Trust. Insurance records from the Hartford Fire Insurance Company, renewed in 1920, name the insured party as Whitmore Foundation, care of Farmers Loan and Trust. No correction, no addendum, no reference to Harbor Real Estate Trust. The discrepancy was functional, not accidental. Each record reflected the version of ownership most useful to its context. To the tax authorities, the property was held by Harbor, to insurers, by the Foundation, to society, by no one. When examined in the registry's physical ledgers, the inconsistency stands out visually. The 1919 entries ink is darker than surrounding entries, its typeface slightly misaligned, likely produced on a different machine. The pagination jumps. Page 197 ends with an unrelated E. Transaction. Page 198 begins mid-sentence with said parcel conveyed. The absence of a preceding clause indicates insertion. The subsequent page, 199, resumes the normal sequence. Whoever added the record did so with precision sufficient to mimic continuity, but not enough to erase the mechanical evidence of intervention. Legally, such anomalies are supposed to trigger review, yet no review occurred. When the Rhode Island Title Reclamation Act of 1920 prompted verification of dormant deeds, the Whitmore parcel was marked verified, complete. The report cites Harbor Real Estate Trust, Estier 1913, as owner, a date that repeats the fiction introduced by the backdated filing. From then on, every audit and municipal inspection cited the same inherited falsehood. The inconsistency, once embedded, became the new truth. The consequence extended beyond one property. Once the technique proved viable, other estates adopted it. The Belcourt, Vanderbilt, and Linden Hill holdings show similar retroactive corrections in their chains, entries marked nunc pro tunc with convenient gaps between deed and filing. These errors always leaned in one direction, toward preserving control while erasing liability. No one ever lost by them. In the bureaucratic logic of the Gilded Age's aftermath, perfection was less believable than precision that looked human. A smudge, a delay, a clerk's oversight, carefully placed to camouflage intent. Archivists who later studied these ledgers noticed the pattern. In a 1954 internal memorandum from the Rhode Island Historical Records Commission, one analyst wrote, "Many trust properties exhibit period lag between deed execution and registration, often aligning with fiscal changes. Statistical coincidence improbable." The understatement masks what the records themselves make plain. The same offices, the same trust companies, the same handwriting recurring across years and entities, producing errors that all resolved in the same financial direction. Among the surviving originals, one detail captures the human dimension of the manipulation. In the margin of the 1919 deed, below the registrar's initials, someone, perhaps a clerk, scribbled faintly in pencil, corrected twice already. The remark was never erased, but lightly struck through. It reveals awareness without defiance, the machinery of compliance operating with quiet complicity. For the estate, the inconsistency did what no formal strategy could. It allowed continuity to survive legal reform. The 1919 deed effectively bridged the gap between pre- and post-taxation eras, ensuring that, on paper, The Whitmore property remained a charitable asset predating all new obligations. The false date was less deception than design, a prophylactic against transparency. Looking back, the pattern forces a question. How often do the same hands produce the same mistake in the same direction? The recurrence of errors that protect power suggests that coincidence was never the governing principle. In historical records, as in finance, accuracy can be faked, but consistency cannot lie. The 1919 page still sits within the registry's bound volume, the ink slightly darker, the type misaligned, the date impossible. And yet it remains the official record, proof in the bureaucratic sense that fiction properly formatted becomes fact. The book closes there with the registrar's seal still visible beneath a faint shadow where the ink bled through. The next chapter of the investigation begins not in what was added, but in what those additions allowed to endure. By 1929, the structure that had kept the Whitmore property invisible for more than 3 decades stood intact. But the world around it was collapsing. The stock market crash of October 24th, followed by the financial contagion that would define the Great Depression, turned public sentiment violently against the quiet networks of trusts, foundations, and holding companies that had flourished since the Gilded Age. For the first time, the secrecy that had shielded fortunes became a source of danger. Newspapers discovered that invisibility, once a mark of refinement, now resembled guilt. And if the right reporter had connected the dots between the Whitmore Foundation, Harbor Real Estate Trust, and Farmers Loan and Trust Company, the entire facade could have unraveled. The risk began as rumor. In December 1929, the Providence Journal published a piece titled, "Phantom Owners of Newport, Who Keeps the Lights Burning?" The article, inspired by the sight of staffed but uninhabited mansions during an energy rationing campaign, speculated that trust-managed holdings were being used to mask private wealth from taxation. Though no names were printed, the description of one estate, ivy-covered, south of Ruggles Avenue, maintained year-round, fit the Whitmore property precisely. Inside the offices of Farmers Loan and Trust, the article was clipped and circulated under the heading, "Potential Exposure, Local." A handwritten note on the margin reads, "Public interest high, do not correspond." The action taken in response was subtle but coordinated. Within a week, the Foundation's secretary authorized the reclassification of all property-related expenditures under cultural preservation, diverting maintenance and wages away from identifiable categories. Ledgers from 1930, preserved in the bank's archives, show the shift. Groundskeeping becomes Landscape Preservation Grant. Staff E. Payroll turns into Educational Fellowship. Language became a firewall. Nothing changed in practice. The staff still worked. The gardens were still tended. But to any auditor, it now appeared as philanthropic activity. Had a journalist pursued the lead, the paper trail would have been deceptively clear. The property's title pointed to Harbor Real Estate Trust, whose trustees were employees of Farmers Loan and Trust. The Foundation's filings listed the same bank as custodian. Each entity was distinct on paper, yet all mail routed to the same floor of the same building at 23 Exchange Place, New York. A determined investigator might have noticed that the signatures across documents, those of RTW, E.M. Bristow, long deceased, and J.S. Mallory, shared similar penmanship. But without subpoena power, the inference would have remained speculative. In 1932, a congressional subcommittee began hearings on interlocking directorates and tax avoidance through charitable trusts. The New York Times published transcripts naming prominent banks and foundations that managed estates for indefinite benefit. Farmers Loan and Trust appeared on the list. For several weeks, silence filled Newport's social circuit. Some estates hastily transferred their titles back to family names, seeking moral legitimacy through exposure. The Whitmore Foundation did not. Instead, it doubled down on invisibility, asserting in correspondence that its properties were non-revenue assets held in custodial trust. That statement, technically true, neutralized further inquiry. The consequence, however, was reputational tension. If the press had connected the Whitmore Foundation to its beneficiary, the revelation would have pierced the illusion of charity. The house might have become emblematic of the hypocrisy of old wealth, lavish preservation under the banner of philanthropy during an era of breadlines. The family's discretion was not merely aesthetic now, it was existential. Newport's elite, already under attack for their isolation, could not afford association with paper entities designed to evade accountability. There are signs of how close exposure came. In May 1933, a young reporter for the Boston Evening Transcript, researching the aftermath of the Knickerbocker Trust collapse, filed a public record request for property assessments linked to inactive corporations in Newport County. Among the entries she reviewed was the parcel still registered to Harbor Real Estate Trust. Her handwritten index card, preserved in the paper's archives, reads, "Belongs to Cultural Foundation, verify with Farmer's Loan." The follow-up never appeared in print. The transcript ceased publication months later amid financial strain. A coincidence, perhaps, but a fortuitous one for the Whitmore estate. Had that article run, the implications would have extended far beyond scandal. The property's ownership model, replicated quietly across Rhode Island, would have been scrutinized as a template for concealment. The Internal Revenue Service, newly empowered under the 1913 income tax and further strengthened by the Revenue Act of 1932, could have reopened filings retroactively, invalidating charitable exemptions. The trust officers, already under investigation for their roles in speculative banking losses, might have faced perjury charges for misrepresentation of beneficial ownership. For the Whitmores, the damage would have been irreversible, not only financial, but social. In an era when public disgrace often meant exile from polite society, a single exposé could have rendered their name toxic across every boardroom and ballroom from New York to Boston. Internally, the awareness of that risk shaped policy. Meeting minutes from the Whitmore Foundation Board, dated August 17, 1933, include the entry, "No public correspondence regarding assets. All inquiries to be directed to counsel." Below that, another line, added later in pencil, reads, "Photographs of Bellevue property to be withdrawn from publication requests." The board anticipated not just investigation, but imagery, an understanding that, in the modern press, a photograph could indict as powerfully as a document. Even so, silence was never total safety. In 1934, when the Newport Mercury reported on the city's property tax arrears, it listed Harbor Real Estate Trust as among those granted partial abatements for non-profit use. The article drew little attention at the time, but to those who knew, it confirmed what the family most feared, that the name of their shell entity was now public. The following year, the trust quietly merged with another dormant company, Bayview Holding Corporation, dissolving the harbor identity entirely. The maneuver erased the one name that might have been traced to their lineage. The potential scandal never materialized, but its shadow left a mark. The property remained untouched during the economic devastation of the 1930s, even as neighboring estates were sold or subdivided. While others fell into foreclosure, the Whitmore mansion endured, pristine, silent, and tax-exempt. Its survival was not luck, but the product of fear, a defensive architecture built on the anticipation of discovery. The broader irony was that the very system designed to protect reputation now depended on the absence of it. The Whitmore's name, once currency, had become a liability. Their anonymity preserved them, but it also erased them from memory. When Newport's post-war revival began decades later, guidebooks described the mansion as an unidentified trust property of uncertain origin. No one remembered the family, everyone admired the house. In retrospect, the risk of scandal defines the turning point of the entire chain. Before 1929, secrecy had been protection. After the crash, it became accusation deferred. The Whitmore case demonstrates how an elegant concealment can age into a fragile lie, stable only while unexamined. The property's endurance depended on a single collective decision that no one, from clerk to journalist, would ever press too hard on the neatness of the record. The last surviving newspaper clipping tied to the episode, a folded copy of the Providence Journal article, still sits inside the Whitmore Foundation's 1930 annual report. Its edges are brittle, the ink faint, but one annotation stands out in blue pencil beside the headline, "Phantom Owners of Newport." A single word, underlined twice, "avoid." And that is where the line between scandal and silence held, balanced on the thin paper of a world that understood what it must never confirm. By 1948, what had begun as a precaution had hardened into a system. The Whitmore property, still immaculate and still legally unowned, no longer needed concealment. It had something stronger: precedent. The post-war years brought a new language to describe old evasions: preservation, heritage, estate management, terms that sounded civic, not defensive. Silence had become an administrative function, reproduced across ledgers, correspondence, and policy, until secrecy was no longer an exception, but an expectation. The first concrete sign of this normalization appears in the minutes of the Rhode Island Society for the Preservation of Historic Landmarks, dated June 2, 1948. The Society's executive board approved a strategic collaboration with several privately held estates to ensure continuity of architectural integrity without public interference. The Whitmore Foundation appears in the list as a partner institution. No property address is given, but the Foundation's mailing address, 23 Exchange Place, New York, confirms the link. The partnership formalized what had long been practiced informally: the merging of private discretion with institutional legitimacy. The action that cemented this change occurred later that summer. On August 14, 1948, the Foundation filed a renewal of its charter with the state of Rhode Island. The new documents replaced every instance of benefactor or trustee with administrator or custodian. Legal counsel at Whitmore and Dyer, the family's long-serving law firm, inserted a standard clause authorizing permanent custodial management of heritage properties of cultural or educational value. The language, copied almost verbatim from Preservation Society templates, neutralized any lingering implication of ownership. In bureaucratic terms, the property was no longer being hidden, it was being maintained. The change in tone rippled outward. Estate ledgers from 1949 show repetitive entries under a new category: Maintenance Preservation Fund. The amounts are nearly identical each year, suggesting an automated renewal. Correspondence from Farmers Loan and Trust, now rebranded as First National City Trust, adopts a similar rhythm. Letters once signed by named officers now close with the generic Office of Property Administration. The personal had been erased not by omission but by formatting. Internally, even record-keeping adapted to the vocabulary of discretion. Within the Foundation's archive, now a climate-controlled basement beneath an insurance building in Providence, folders labeled "Restricted" multiplied. Their contents are mundane: invoices for roof repairs, heating contracts, gardening schedules. Yet each bears a note reading, "Private papers, do not circulate." What had once been exceptional secrecy was now clerical routine, carried out by staff who likely had no idea what was being protected. The Registry of Deeds reflects the same inertia. Beginning in 1950, renewal filings appear at 5-year intervals, identical except for date and signature. Each lists the grantee as Whitmore Foundation, Custodial Branch, the address unchanged since 1901. The witnessing notary alternates between two individuals employed by the same law firm, their names interchangeable across decades. No review was ever triggered because every form was perfectly compliant. Perfection, once suspicious, had become expected. The consequence of this bureaucratic stability was institutional amnesia. By the early 1950s, younger clerks at the Registry and Tax Assessor's Office regarded the property as an ordinary trust holding. The file's age and cleanliness discouraged questions. The absence of a living claimant made it easier to file under routine renewal. The estate's silence had become so embedded in the machinery of record-keeping that challenging it would have seemed abnormal. Outside the archives, Public perception aligned with the narrative of preservation. A 1952 article in the Newport Herald praised private efforts sustaining the town's architectural dignity, citing unnamed foundations that maintained historic homes without commercial intrusion. The accompanying photograph, cropped to avoid signage, unmistakably shows the Whitmore facade. The caption reads, "Preserved by a private trust. Name withheld at request of administrators." The tone is admiring, not accusatory. What had once been a scheme to avoid exposure now passed as civic virtue. Even within professional circles, the phrase estate management evolved into euphemism. Legal journals from the period, including the New England Property Review, 1954, published articles detailing best practices for preservation trusts. Their model examples, anonymous entities, perpetual renewals, decentralized custodianship, mirror the Whitmore structure exactly. One author, an attorney from Boston, summarized the philosophy: continuity requires discretion, identity impedes stewardship. The sentence could have been lifted directly from the Foundation's internal memoranda. By then, even the government had accepted silence as preservation. During the National Trust for Historic Preservation's 1956 survey of Newport estates, the Whitmore property was classified as privately maintained restricted access. No further inquiry was made. The survey's methodology assumed that private oversight implied financial legitimacy. In effect, secrecy became policy, self-reinforcing, self-justifying, invisible. Administrative correspondence from 1958 demonstrates how fully language replaced explanation. A letter from the Foundation's counsel to the Preservation Society states simply, custodial oversight renewed, no public programming planned, no justification, no context, no signature beyond Office of Preservation. The letter reads like a placeholder, yet it was sufficient. The estate remained untaxed, unlisted, and unexamined. Financially, normalization paid dividends. The property's insurance premiums were classified under heritage asset maintenance, qualifying for reduced rates. Its operational costs, filed as cultural preservation expenses, became tax-deductible. Each administrative layer reinforced the fiction until no one could separate compliance from concealment. What makes the 1948-1960 period distinct is not what was hidden, but how casually it was maintained. The staff at First National City Trust renewed the estate's insurance with the same indifference they applied to any dormant account. Preservation became the public face of procedural inertia. Every renewal, every affidavit, every notarized line repeated the same quiet thesis: continuity is legitimacy. By the time the next generation of administrators inherited the files, the original motive, the fear of exposure, the avoidance of tax or scandal, had been forgotten. What remained was a system that reproduced itself automatically, its origin story erased by repetition. The silence no longer protected anyone in particular. It protected the routine itself. Inside the archive today, one can trace that transformation in handwriting. The ledgers that begin with ornate penmanship in 1891 end by 1961 in typewritten uniformity. Margins once filled with notes and initials are blank. The process had reached its logical end, the disappearance of even the memory of secrecy, and so by the late 1940s, the Whitmore estate ceased to be an anomaly. It became a template, a model for how the American preservation movement quietly absorbed the language of concealment into the architecture of respectability. The silence that once required effort now sustained itself through habit. In a back room of the Providence Archive, a single file bears witness to that transformation. A renewal form dated October 3, 1948, stamped "Received Routine." The signature line reads simply, "Whitmore Foundation, by Administrator." No name follows. The ink has not faded. The handwriting is neat. The silence by then had learned to sign its own name. In 2026, the Whitmore property still stands, its facade restored, its gardens immaculate, its ownership unchanged in the one way that matters most. It belongs to no one. The structure that began as a late Gilded Age trust has not dissolved. It has simply adapted. What was once the Whitmore Foundation now exists as Whitmore Preservation LLC, registered in Naw, Delaware, with a single member listed as another entity, Easton Administrative Holdings, incorporated in 2004. The layering is legal, modern, and unremarkable. The design is centuries old. Accessing the trail today requires digital excavation. The Newport County Assessor's online database lists the parcel as privately managed historical asset, exempt use. The owner field reads only Whitmore Preservation LLC, custodial. The mailing address remains 23 Exchange Place, though the building is now leased to a global finance firm whose receptionist, when asked about the company, replies that the suite number is used for mail forwarding. Requests to the Secretary of State's office confirm that the LLC files on time, pays its minimal fees, and reports 0 employees. The signature on the most recent annual report, digitally notarized in April 2026, bears only the name Authorized Representative. The action that connects past and present is visible in metadata rather than paper. The 2026 deed image in the registry's digitized archive is a PDF scan of the 1948 renewal form, its notary seal blurred by compression. Attached is a newer certificate titled Title Confirmation, Non-Conveyance Update. The language is circular. Ownership remains vested in custodial entity of record. In plain terms, nothing has changed because change itself would expose continuity. Attempts to trace the line further only reproduce the same pattern the Whitmores engineered over a century ago. The IRS database of tax-exempt entities lists Whitmore Preservation LLC as a disregarded entity wholly owned by a charitable trust. The trust, in turn, reports assets held in perpetuity for the preservation of cultural heritage. No board names, no trustees, no contact person. The estate pays no property tax, receives occasional grants for historic landscaping, and appears in tourist brochures under the vague heading Private Estate, Limited Access. Visitors see it from the street, admire its symmetry, and move on. The continuity is not accidental. In 2011, a Real Estate Management Act in Rhode Island allowed historical properties owned by charitable or custodial entities to qualify automatically for renewal if no material change occurred. Whitmore Preservation LLC avails itself of this clause annually, submitting digital affidavits that the property remains under preservation and not subject to transfer. The county clerk's office processes them through an automated queue. The filings are time-stamped but never reviewed by a human unless a dispute arises. No dispute has ever arisen. Financial traces confirm the efficiency of this vacuum. The 2025 Form 990 PF for the Associated Trust reports exactly $112,000 in annual expenses, matching, within rounding, the maintenance budget logged by the Whitmore Foundation in 1958. Inflation should have multiplied that figure 20-fold. The repetition suggests a placeholder number, perpetually renewed to sustain the fiction of modest upkeep. The trust's investment portfolio lists U.S. Treasury bonds and real property maintenance contracts. Inquiries sent to the accounting firm named on the filing receive polite replies citing client confidentiality. The consequence of this continuity is not hidden corruption but institutional symbiosis. Local preservation boards reference the Whitmore estate as an exemplar of private stewardship. Law schools cited in property law courses as a case study in perpetual trusts and cultural exemptions. The mechanism that once avoided scrutiny now teaches compliance. The silence has become doctrine. When cross-referenced with satellite imagery, the paradox deepens. The house remains occupied, lights visible at night, grounds maintained, but no vehicle registration, postal delivery, or utility billing appears under the LLC's name. The electric account is registered to Regional Facilities Group, another Delaware shell linked to multiple heritage properties nationwide. Ownership has become a cloud architecture of legality, a self-sustaining algorithm of absence. The registry's digital portal still recognizes the property under its 1891 parcel ID. Clicking chain of title returns a chronological list: 1891 deed, 1901 re-recording, 1919 nunc-pro-tunc correction, 1948 renewal, 1973 incorporation amendment, 2004 conversion to LLC, 2026 compliance filing. Every link opens an image. Every image resolves to a seal. Every seal leads nowhere. The record is flawless. Because flaw was the one thing its architects forbade. Institutionally, no one benefits directly anymore. The Whitmores are long gone. Their descendants live under other names. Yet the system they designed continues to profit from their logic. Law firms earn annual retainers for automatic renewals. Banks collect custodial fees for accounts that never close. Preservation organizations point to the estate as proof that private management ensures longevity. And the state, relieved of responsibility, lists the property proudly among its protected landmarks. What began as concealment matured into governance. When interviewed in March 2026, the Newport Planning Department's deputy director summarized it without irony. The estate operates within full compliance. The structure is self-maintaining. He meant financially, but the phrase captures the deeper truth. The silence now maintains itself. No decision, no conspiracy, no intervention is needed. The mechanisms of absence run on schedule. This endurance also exposes the system's philosophical fault line. The Whitmore property shows that what law calls a gap is not a failure but a feature. The absence of ownership is not neglect, it is protection through omission. The building survives precisely because it belongs to a category designed never to end: custodial, charitable, compliant. If one searches for liability, the search itself becomes proof of misunderstanding. Physically, the mansion remains frozen in curated stasis. Recent photographs from the Newport Preservation Survey, 2024, show restored windows, repainted shutters, and newly replaced slate roofing, improvements funded, according to the report, by anonymous endowment. The only visible change is the security system. Discrete cameras mounted beneath the eaves, their lenses angled not outward but inward, monitoring the perimeter of privacy. In the quiet of April 2026, a researcher opening the online title viewer might notice a final peculiarity. Beneath the signature block of the latest filing appears an automated timestamp, electronically certified by Clerk AI Autofile v3.2. No human hand touches the record anymore. The cycle has completed itself. Digital systems now perpetuate the very opacity once crafted in ink. And so the Whitmore property endures as an active ghost in the civic landscape, assessed, catalogued, admired, but legally absent. Its walls still stand where the ocean light hits them each morning, but their meaning has shifted. The house is no longer a symbol of wealth hidden from view. It is evidence of a loophole made permanent. The silence that began as defense has become architecture. The registry's final image, Book 217, page 342, digitized and indexed, ends with the same words it carried in 1901. Ownership confirmed by custodial entity of record. The phrase has outlived every person who ever signed it, and in 2026, as in 1891, it still tells the truth exactly as intended: complete, correct, and empty. By mid-2026, the Whitmore estate's silence had evolved into something approaching self-governance. What earlier generations of lawyers maintained manually is now perpetuated by systems built to interpret compliance as continuity. Each quarter, software at the Rhode Island Secretary of State's office flags dormant LLCs for renewal. Those that file correctly remain untouched. The Whitmore Preservation LLC has never failed a submission. Its registered agent, Easton Administrative Holdings, itself a Delaware corporation, uses an automated service that drafts renewals from previous year's templates. The same language, the same amounts, the same certifying statement. Property preserved for cultural continuity. The repetition is not oversight, it is immortality through formatting. The action sustaining this arrangement occurs in milliseconds. Every April, an API connection between Easton's accounting portal and the state registry uploads a pre-filled form, authenticated through encrypted credentials first issued in 2004. No one reads it. The file passes automated verification, generates a PDF acknowledgement, and archives a digital receipt. The entire process takes 12 seconds. The house renews itself while no person is watching. Further inquiry shows that maintenance contractors, landscapers, electricians, surveyors are all hired through a procurement intermediary called Heritage Facilities Group, which manages multiple properties under non-disclosable custodial entities. Payments are routed through escrow accounts in New York, aggregated with other estates' budgets, and dispersed via ACH transfers. Each vendor's tax form lists Heritage Facilities Group as payer, not the Whitmore estate. In effect, even the act of fixing a broken shutter or pruning a tree participates in the architecture of anonymity. When archivists at the Newport Historical Society attempted in 2024 to compile ownership data for their Mapping the Mansions digital exhibition, the Whitmore E. property appeared as a gray placeholder, private trust, non-public record. A footnote mentions that public access to historical deeds is temporarily restricted due to custodial agreement. The restriction is permanent. Inquiries to the county recorder return automated emails. Record exists. Access limited by preservation covenant. The irony is complete. Transparency itself is listed as a risk to preservation. The consequence is a kind of bureaucratic afterlife. The Whitmore estate participates in civic life without existing as a legal person. It pays no taxes but contributes to tourism revenue through postcards, walking tours, and drone footage. Travel bloggers photograph its gates and tag it with Brown Historic Newport. None realize the property is technically a ghost, an object of heritage managed by an entity that cannot die because it never lived. Inside legal scholarship, the case has acquired a quiet notoriety. A 2025 article in the American Journal of Property Law cites the Whitmore chain as an early prototype of algorithmic trusts, noting that digital compliance frameworks have inherited the Gilded Age's logic of self-perpetuating invisibility. The author, a professor at Columbia, concludes that non-ownership has matured into a stable governance form. In this sense, the Whitmore structure is no longer an anomaly, it is precedent. Locally, officials treat it with reverence. The Newport Planning Board's 2026 report on adaptive preservation refers to the estate as a successfully contained heritage ecosystem. The phrasing suggests stewardship, yet the reality is that no one steers. The absence of decision-making has become a virtue. Because the property never changes hands, it never triggers reassessment or review. Longevity is achieved through motionless legality. Digitally, its invisibility has deepened. Searches through property data aggregators show the Whitmore parcel listed under Data Withheld, Heritage Classification. Machine learning. Models used by insurance firms flag it as low risk. Algorithms, like the clerks before them, reward stability and penalize anomaly, and the Whitmore record, unchanging for 135 years, represents the ideal of systemic calm. The silence also feeds on language. Every document produced by the LLC uses terms so generalized that they resist inquiry: heritage continuity, cultural stewardship, environmental integration. These phrases act as encryption keys, too abstract to contest, too respectable to challenge. Preservation has become the lingua franca of concealment, yet traces remain of human intent. In January 2026, a local drone photographer uploaded aerial footage showing a small black SUV parked beside the main gate at dawn. The license plate was unreadable, and the footage was later removed after a copyright claim by Whitmore Preservation LLC. The act of deletion itself reveals what the record conceals. Someone, somewhere, still guards the border between visibility and belonging. The Whitmore property's endurance proves that the void in law is not an accident but an instrument. The statutes enabling charitable and custodial ownership were never rewritten because their vagueness serves both regulators and beneficiaries. The state collects compliance, the custodian collects continuity. In between lies a building that outlived its creators by converting discretion into permanence. Standing before the gates today, a visitor sees a perfect tableau. Ironwork polished, gravel, freshly raked, curtains drawn. Nothing suggests neglect or occupation. Only the faint hum of security cameras and the soft click of a motion sensor acknowledge the present. The estate no longer hides. It simply operates, synchronized with servers, renewed by scripts, preserved by indifference. And so the story circles back to its origin. A property conceived to have no owner, still fulfilling that design. The ledger's newest line, certified current as of April 2026, completes the continuum that began in ink and now persists in code. The building stands as proof that disappearance, once deliberate, can become automatic. The record, unbroken for 135 years, continues to confirm nothing and reveal everything about how permanence now resides in the empty space where a name should be. In the end, the Whitmore estate does not stand as an accident of record-keeping or a clerical oversight preserved by chance. It stands as a demonstration, quiet, durable, and unnervingly refined, of what institutions can authorize when they choose not to conclude a story. In 1891, a deed entered the Registry of Deeds as a beginning, with language meant to anchor land to a name. By 1901, the paper was made cleaner than truth, polished through re-recording, the responsibilities thinned into a quitclaim, the chain taught to speak in corporate phrasing instead of inheritance. In 1913, as federal law matured and public visibility became newly taxable, the surname faded from directories and captions, leaving the building present but its patron absent. In 1929, and again in 1933, when the nation's patience with financial secrecy turned brittle, the danger was no longer theoretical. A curious reporter, a single committee hearing, one precise column of ink connected in public could have transformed preservation into indictment. And by 2026, the mechanism has not collapsed under modern scrutiny. It has upgraded. The old trust logic persists in contemporary wrappers, LLCs, registered agents, digital law, affidavits, automated renewals, so that the structure survives, not because it is hidden, but because it is compliant. What we traced was not a scandal, but a chain of function. The first evidence that should not have been there, the context that made ownership dangerous, the internal decision that treated a name as a liability, the alteration that reduced a title to administrative perfection, the beneficiary who gained control without exposure, the disappearance of attribution across public life, the inconsistency that bent chronology into convenience, the risk of the press connecting what paper tried to separate, the normalization that turned maintenance into a respectable cover, and the present, where the architecture of absence runs like a clock. That is the institutional moral. Systems do not lose owners, they authorize limbo, a category where responsibility can be deferred without ever being denied, where assets remain intact precisely because the record is designed to arrive nowhere. Documents are not merely memory, they are infrastructure. They determine what can be claimed, what can be challenged, what can be inherited, and what can be forgotten, without anyone being able to prove who benefited from the forgetting. And when the infrastructure is built to protect the incomplete, reputations survive not through innocence, but through design. If this story resonated with you, let us know. It tells the algorithm these forgotten halls are worth exploring again. And leave your thoughts below because every perspective helps illuminate what history tried to bury. Subscribe quietly so that you're here when the next sealed door finally opens. And if you're willing to step deeper into the shadows, the next chamber awaits. For somewhere beyond these gates, in another ledger, another archive, another set of pages too clean to be trusted, a similar absence is still being renewed, annually, automatically, respectfully, until the public forgets to ask what the record was built to prevent it from ever answering. Some secrets survive only because those who feared them left no one to tell the truth.